That's a good place. Yeah, Jupiter hadn't grown that. All right.
Test. I'll talk to you some more.
Yeah, I gotta go see about my circus.
Where are you?
Family. With the Clash of Cultures.
Do you still have the hearing today?
Yes.
Good morning. Good morning, Reagan. Look at them, Zoe, the whole group. How are y'all? Good to see you.
Yes.
You sat on up there, yeah. Take the row on the right. How are y'all? Good to see you. Colin, what's going on? How you doing? Good. Were you in the class?
This is my friend. She got in our class.
Okay, well, welcome. Are you in criminal justice too?
Yes.
Okay. Now what are you doing? I'm sorry? One more time. Okay, that's fantastic. Where? What town? Good for you.
One's already else, if you could give them 2 seconds.
One, sure.
The district.
Oh,
District.
okay. Tim, can you hear us? Tim, can you hear us?
Fine. I'll bring it back.
All rise for the jury.
You may be seated. You may be seated. Good morning, ladies and gentlemen. Thank you for being here on time. We will get started with the witness that was on the stand when we left yesterday. Ma'am, please remember that you are under oath. Defense?
And Judge, I think I'd seek to move into evidence Defense Exhibit 7, Defense Exhibit 8 by agreement. They are two body cams with two separate police officers.
No objection.
Defense Exhibit 7, Defense Exhibit 8 are admitted.
Judge, it's playing on my computer, but it's not reflecting.
I think you can move it to the side.
Ms. Wilkerson, do you remember telling this officer that y'all were both fighting?
Yes,
Do you remember telling that officer that you were both pushing each other?
yes,
Do you remember telling him that you really didn't want to get in trouble?
no,
Mr. Darwin, can you use your microphone, please? Thank
Yes,
you.
ma'am, I apologize.
Thank you.
And that's what our officer always saying, it's stop now, so just finally take a breath. Everything right now, we just want to make sure that everyone is all right. So you're saying, I had a little bit, when you're talking about Officer Gavin, our Officer Gonzalez, that, you came home from work and he thought you were cheating on him?
That's why I was at work. Things just kind of, not arguing, like text messages and stuff like that, and I had gotten home finally around like 11:30. And he was asleep, and so I was like, okay, kind of sort out and stuff, so I just went to bed. 2 or like 12:30 probably, and then, I don't even know what time it is right now, but like as soon as we woke up, just like, making our bathroom break, you know what I mean? It just kind of stepped up again, and then I called like 5 or 10 minutes into it. So.
You got what?
I had just called like 5 or 10 minutes into like the argument, because I didn't know what to do at that point, it was so late at night, so.
Have y'all argued before? Or is
We've
it-
been together 5 years, so, I mean, like, we had our ups and downs.
Yeah, I get a relationship.
Yeah, everything's been like really good, we can always just.
I mean, you have your normal arguments or tend to, that's pretty heated, some back and forth, is that something that's happened before too, or?
It's happened before, but not for a really long time.
Or what happened I know you said it was a really long time ago, what happened now? I did that long ago.
I can't remember.
So any,
Ms. Wilkerson, do you remember telling that officer that, you did hit Jacob in the face to get him away because he kept calling you names and you didn't like it?
I remember you showing me that on the video yesterday, but
Um,
also with this, I believe I was saying I don't want him to get in trouble, not I don't want to get in trouble. That's what I believe I was saying.
yes.
anybody like, the shoving match, anybody throw punches or?
I mean, to be honest, I did hit him in the face to try and get him away because he kept calling me names and I didn't like it. But I think he shoved me too, I shoved him too, like it's on both ends.
Did you just explain it's on both ends, ma'am?
Yes, I did.
So do you know what happened to your neck here on the side?
Probably just from his hand.
His hand? How was his hand at it? He did choke you? Very much.
But to like restaurant, I don't want to restaurant as well.
We want to make sure that,
And you explained that you didn't want to press charges, correct?
I explained that, but I also did say that you did choke me.
Yes, ma'am.
that this isn't something that's ongoing, so we want, honesty is always the best, we want to make sure that everyone's okay. All right, so,
I could hit him too.
well, you're saying you hit him to get him, did he was calling names or to get off of you?
He was calling me names, I had to get off.
And again, you explained that because he was calling you names first, that you hit him.
Yes, but the rest of that sentence I was saying because to get him off of me as well.
Do you remember telling this officer that you never had this happen before?
I don't remember that.
Do you remember telling this officer that you never wanted to call the police before?
I don't remember saying that, but that is true.
For me, both of them.
Okay. So now that's out there. What, I know you're saying back and forth and all that, but now that's on the table, because I understand our emotion and everything, but I just, if you need to take a breath, by all means, but with that being out there now, what? Some push and shoving, at what point? I'm just, by all means, take a breath.
Delegating me
And y'all, and it's good that you did. Like, we want to make sure that everyone's safe, okay? Good. I think that'd be,
I have a key.
let's get it going now. So. Whenever, so we were saying, at what point did that happen? I know you're saying it happened fast, but pushing, shoving. Were you standing or how did that happen?
Yeah, I don't remember exactly how, but I know we were both standing and, I don't remember who did anything first, that's the thing.
Okay.
But he kept calling me like a cheater, and I don't like to be called things that I'm not.
Mhm.
And, And so like I was trying to get him out of my face, and so I'm trying to get him in the face. And like, he hit me, he choked me around the neck, and just like against the wall.
One hand, two hands.
He was one, I don't remember.
No, and it's one of the things that there's definitely a mutual back and forth kind of thing of,
So there, the officer saying this is mutual.
I suppose.
Has he ever choked you before or strangled you?
No.
Now, on direct, you explained that you had been choked before by Jacob.
I don't understand what the meaning of that question means.
Did you testify to the state that prior to this incident, Jacob had choked you before?
Yes, because he has.
Okay, but you said no here in the video, correct?
Yes, because I was scared and did not want him to go to jail.
definitely takes it to another level.
So what's gonna happen tonight is he's gonna end up on the jail. Okay,
Is there a way that we cannot do that?
well, so whenever there's strangulation, it's somebody's gonna end up on the jail.
And here the officer saying if there's strangulation, somebody goes to jail, correct?
Correct.
You're saying y'all were kind of back and forth, but can you tell me how he strangled you?
Just kind of. Against the door.
And which door would that be? That door back on that side? Was it one hand, two hands? That number? But it was, if it was a hand or a forearm or? Hands? Okay. We know what hands about how long it was? 2 seconds. On a scale of 1 to 10, 1 being the lowest and 10 being the highest, how would you rate his grip? And then with that same thing, 1 being the lowest and 10 being the highest, how would you rate the pain?
So here you explained that it was just a few seconds he choked you.
Yes,
Didn't you tell the state it was like 10 seconds?
I don't remember exactly how many seconds I told the state.
Okay, and what did you tell the state about the pain level it was?
I don't remember saying anything about the pain level yesterday.
But here you just said it was a 3, correct?
Yes,
Now, you told the police that there was only 1 time of strangulation, correct?
I believe I said that, but I also believe in my statement that I wrote down it was multiple times. If I remember correctly.
Now, on January 5th, 2022, you provided a statement, Ms. Wilkerson, to the police, correct?
Correct,
And you did so there at your house there?
correct.
And you're saying that, that you put multiple times in your statement that you were choked?
If I remember correctly,
Well, could I show you your statement to reflect your recollection? May I approach the witness?
Yes, ma'am.
Thank you. I'm showing you what's been marked. I can't talk and do that at the same time, sorry. Thank you, Ms. Cassia. Ms. Wilkerson, I'm showing you what's been marked just for identification purposes as defense exhibit number 9. If you could please look over your statement, ma'am, just to refresh your recollection. I mean, you put in such statement that you were just choked once, correct? And there was nothing about you being choked on a bed, correct?
No,
Now, do you remember that you said here that there was just one time that you were strangled here?
yes, there is that.
Is it, we just said the one time, or was there multiple times said?
Now, do you remember telling the police in this statement that we've hit each other before a couple of times? Mostly it was me, but that was over a year ago.
I do not remember that.
Okay. You also remember subsequently getting asked how many times prior did it get physical? And you answered maybe just once.
I don't remember that either.
And then I know you're saying, something happened a long time ago, but, is there any history of any violence or any past regulations? Because I understand this was the first time that this has happened.
Yeah, and we've hit each other before. I'm doing enemies, nice to meet you, like I said, I was like. So.
Any police involvement or just?
So.
You're saying there was a little bit in the past, or just how many times do you think? You've been together a while, but any sort of physical between the two of you, fighting wise?
Okay, so before you said mostly it was you the prior time, correct?
I did not hear those words personally.
Would it refresh your recollection if I replayed that for you, ma'am?
If it was the video you just played, I don't believe I said that.
Okay, we go back.
But I understand this was the first time that this has happened.
Yeah, and then we've hit each other before. I'm doing enemies, nice to meet you, like I said.
You don't remember just saying mostly it was me there?
I said I hit him, he's hit me. I didn't say mostly me.
Are you able to turn that up by chance? The volume?
I'm not.
Or is Ms. Castillejo able to? Is that as high as it goes?
I am not able to over here.
Regulations, and I understand this was the first time that this has happened.
Yeah, and then we've hit each other before. I'm doing enemies, nice to meet you, like I said.
You're denying what you said mostly it was me
I
there?
did not say mostly me, I said he's hit me.
Okay.
That is what I said. I would not say mostly me because it was not mostly me.
Okay.
And that but it was actually a much yes.
I told him to leave. Yeah. The wind just from your ear, and then I walked outside, and it was super outside, and like just standing here. Arguing.
But that's what we got here, right? So what happened?
I just had to tell her on me to talk. I was trying to talk to anybody.
Oh, okay.
Yeah, I just had called and then ways to meet it off.
That was fine. Have you ever done that before?
So here you're explaining how you called 911 and had the phone in your pocket, correct?
Correct,
And Jacob didn't know that you would call 911, correct?
correct.
Gary, I'm sorry you're looking for that. The thing is to get away from that also is, and I want you to understand that this is not a normal relationship. And it's very scary whether you realize it or not. Even if, you know, even if y'all got an argument, even if you hit him once, you know, it sounds like you hit him to get him off of you, right?
Now here, the officer says, it looks like you hit him to get him off you, correct?
Correct,
And you replies, I hit him because he kept calling me names, correct?
correct, that is what I said.
Yeah.
It was like vehicles, but it wasn't.
So when you hit him, how did you hit him? Like, just a slap or
I
like?
hit him like this, like I got some short hit, like this, like, and then
Yeah, okay.
yeah.
So here you're explaining that you didn't just hit him once, you hit him twice, on the front and back of the head, correct?
Yes. May I have a comment on that?
Sure.
He may not have ever hit me in the face or punched me, but there has definitely been shoving, there's been grabbing, there's been choking. So I consider that abuse as well, along, even if it's not hitting me or punching me. I still consider the rest of it abuse as well. I just never reported it because I never wanted him to get in trouble.
Under medical versus defense exhibit number 8.
Yes.
Protection.
Pretty scary today. Pretty scary. I know you said y'all woke up and started arguing, like, do you remember Felix you up or?
So the copies are still on.
Yeah.
And I think I opened up and he was in the middle of taking them off, right? And so he had said to me like, hey, are we okay? And I was like, what I said was just a little comment. I said, yeah, we're okay for you guys. Give a lot of the positives to the night, you know, like I try to say it lighthearted and just took it for really. So he had said to me like, hey, are we okay? And I was like, what I said was just a little comment. I said, yeah, we're okay for you guys. Give a lot of the positives to the night, you know, like I try to say it lighthearted.
Did you ever, did y'all have a gun?
Not a firearm, like we had a BB gun that I got him for Christmas a few days prior.
Okay. Did you ever hit Jacob with that gun?
I remember mentioning yesterday that after he choked me, I used it as self-defense to push him off of me.
Okay, so now you're saying you did actually hit him with the gun now?
I pushed him with it to get him off of me.
Okay. So where were y'all keeping that gun?
I honestly couldn't tell you. I think it was in our bedroom,
Okay,
but I don't remember if it was mine.
you don't remember. Okay, so you don't remember then how you got the gun, fair to say?
No, I said I believe it was in our bedroom, considering that's where the whole incident happened. I don't. That's where I remember it being.
How did you get the gun?
I don't know. I was basically blacked out at that point because my vision had already gone black.
Okay.
I was in survival mode at that point.
But you didn't tell the police that Jacob had hit you with the gun, or that you had hit Jacob with the gun, correct?
I suppose not.
Um. No further questions, John.
Stick?
Yes, Your Honor. Good morning, Lauren. I just have a couple questions for you. First question, January 5th, 2020, you lived in Hays County, yes? Lived in January. In 2022, yes, sorry. Okay. Thank you. I want to talk about the transition. It's clear from the video. You did not initially want the defendant arrested, and then eventually you told the police what happened and gave a statement.
Correct.
I want to talk about the transition from beginning to end, how that kind of went. Why did you initially tell officers that you did not want the defendant to get in trouble?
Because there had been so many previous fights in our relationship, and I knew with him that we would have a bad day and the next day we would wake up and it would be okay. And I've been with him for 5 years. I've seen the good in this man. I loved him very much. And I didn't want him getting in trouble because I knew where he could be at. And I just didn't want that for him, no matter what he had done to me in that moment.
Had you had that feeling before in your relationship?
Very many times.
When officers first arrived on scene, what were your intentions regarding the relationship with the defendant?
I don't know why I had this thought, but I just wanted them to help calm everything down. Maybe even if he went and stayed somewhere for a night or something, I just wanted everything to be okay again.
When you first made contact with officers, because it's my understanding that your relationship with the defendant ended after this incident. When you first made contact with officers, did you intend for your relationship with the defendant to end? Did you tell officers a version of what had happened to try to mitigate what the defendant did?
Yes, I just wanted to say as little as possible at the beginning.
And so you remember asking a lot to not get in trouble and saying that you love the defendant.
Correct.
At some point in your interaction with the officers, what changed that let you tell them more of the truth?
I'm pretty sure it was the fact that how in that video the officer told me somebody's getting strangled, somebody's going to jail. I think at that point I knew that there was no point if I said anything that it would come back on me from his end. So I thought that at that point it was safe for me to tell my truth because he was already taken away and he wasn't at the house anymore.
And after speaking with officers, you kind of tell them more and more as it goes along. Did you feel more safe the longer you spoke with those officers?
I did. And it was also at the beginning when they were talking to me, he was still outside in the driveway from what I knew. And I didn't know if he was going to be taken or stay. And I knew if he was taken and I told something on him that it would become an even worse night.
Even when you told officers that you had been strangled by the defendant, did you still care for the defendant?
Yes,
Did you really want the defendant to get into trouble?
I did not.
And I want to talk to you a little bit about the specific incidents of strangulation. You told officers, initially you didn't tell them that you had been strangled, you said I'm okay, and then you told them you had been strangled once. How many times were you strangled that night?
From what I remember, it was 4.
Did the officers ask you if you'd been strangled more than once?
I think so, yes.
Why did you only tell them that you had been strangled once?
I think in that moment, I was just thinking of the one whole occurrence, even though it had happened before, or in like the different spots in the room, it was just the one time, if that makes sense.
So you were viewing it as one big event with little subsections?
I was, yes, yes.
I'm gonna talk to you about each specific time that the defendant strangled you. Do you remember where it happened first?
I'm gonna be honest, I do not remember the order, but I remember there was on the bed, there was against the bathroom door, and there was on the floor.
I'm gonna just talk about them in that order then.
Okay,
On the bed, do you remember if he used one hand or two?
I do not remember.
But do you remember his hands on your neck?
Yes,
Were you able to breathe?
hardly,
Partly?
hardly.
Partly, okay. So would you say that your breathing was mostly blocked off?
Correct.
Did it hurt?
It did, but I have a hypertolerance, tolerance, so
Where was the defendant? So you were laying back on the bed.
yes,
Where was the defendant's?
I believe he was on top of me, or like at least on the side of me, was just on top of me, if that makes sense.
I want to talk about the one against the door now. Do you remember if the defendant used one hand or two?
I don't remember.
Do you remember the defendant's hands on your neck and chest?
Yes, I was held against the bathroom door with his hands.
Did it hurt?
Yes,
Could you breathe?
a little bit less than the first time.
So there you said a little bit less than the first time. So was the time on the bed the first time?
I believe so.
So, and then the time against the door was the second.
I believe so, yes.
So escalating a little bit, hurts a little more, can breathe a little less, is that fair?
Yes.
Want to talk about the time on the ground now? Did the defendant use one hand or two?
I don't remember how many hands to use.
But do you remember the defendant's hands on your neck?
Yes,
Did it hurt?
yes, that one hurt the worst.
Could you breathe?
No,
Did you notice? So completely, you couldn't breathe at all.
I cannot breathe.
Did you notice anything else with the time that you were strangled on the ground?
Yes, I got to a point where I tried to open my eyes and my vision was just black and I couldn't see anything.
Where was the defendant? So you were on your back on the ground, is that correct? Where was the defendant?
He was on top of me.
Do you remember if he was crouched over you, off to the side?
I don't remember.
So the officers, you only told the officers about the one event. Was it, your answers to those questions, were they kind of a conglomeration of all of the events together?
In a sense, yes, I would say.
Would you go into that a little bit more?
I think I honestly don't know what I was thinking. It was 5 a.m. 3 years ago, almost. I believe I was meaning it in the sense that I think I was telling them at least that he had only choked me on the one incident. I think I said that because it was the only time I had reported.
Lauren, would you describe your physical size in comparison to the defendants?
I'm about 5'5", 120, and he's about 5'11", 160, 170, maybe, from what I remember. But that's fine.
Did you ever do anything to threaten the defendant, put him in fear of his life or in fear of serious bodily injury during this incident?
No, not that I remember.
Ask the witness.
Sense?
No questions, Your Honor.
May this witness be released?
Yes, Your Honor.
Just telephonic recall, please, Judge, just in case.
Okay, ma'am, you're free to go about your business now, but make sure that if someone calls you, that we can get in touch with you until the trial is over. Thank you very much. State, call your next witness.
State Host Gavin Gonzalez.
Raise your right hand.
Morning, sir.
Morning. You swear to tell the truth, the whole truth, and nothing but the truth.
Yes, I do.
Please have a seat. Adjust yourself close to that microphone and it'll move forward and back. Thank you very much.
Yes.
Now, please tell us your name and spell it for the court reporter.
Yes, sir. Can everybody hear me? Good morning. My name is Gavin Gonzalez. It is Gavin. Last name is Gonzalez, Gonzales.
Say,
Good morning, Officer Gonzalez. What do you do for a living?
Good morning. I'm a police officer. I'm employed with the city of San Marcos. Been employed here for 8 years now.
Did you do anything before working for SMPD?
Yes, ma'am. So prior to working for the police department, I worked for the Texas Department of Criminal Justice for 2 years as a corrections officer and a corrections specialist. And then I did some college before that.
How long have you been a certified police officer?
Since 2016 of June.
Could you walk the jury through some of the training that comes with being a certified police officer?
Absolutely. So a police officer has to be vetted or employed by an agency, and then he will go to a basic police officer academy. There's many across the state of Texas. And the basic police officer academy will entail everything from penal code, traffic enforcement, and then the hands-on use of force, firearms training, driving training. And then sometimes I'll add in many more trainings to make sure an officer is very well prepared.
And did you graduate from?
when you start turning that way, which is fine, it just makes it harder to hear you.
Absolutely.
You just stay closer. Thank you.
Yes, sir.
When did you graduate from the police academy?
That was in the summer of 2016.
Throughout your career as a peace officer, have you received any additional trainings? Is there continuing training that you have to do?
Yes, ma'am. So we have a minimum that we do have a continuous training. There is mandatory classes. And then of course, anything that does pop up, our agency is always well preparing us. And then anything else that we have specialized in, we continue to do training.
Throughout your career as a peace officer, have you had occasion to respond to domestic violence calls?
Correct. So I am a patrol officer. So I handle everything from significant felonies in progress to traffic enforcement, minor complaints, citizen assist, a little bit of everything. And so family violence, domestic assaults is cases we do handle.
And so you said you're a patrol officer. Was that your position on January 5th, 2022?
Correct.
And you went through your duties a little bit. Have your duties changed in any way since January 5th, 2022?
The only thing that has changed a bit, I'm still a patrol officer for the city, is I am now a field training officer, so I'm helping to train the newer officers to come in and also be a mentor and leader for them.
Were you on duty on January 5th, 2022?
Correct. I was working patrol as a midnight shift officer, so my hours were from 7 to 7, so 7 p.m., 7 a.m. And I was working Frank District, which is our westernmost area of the city.
Did you receive a call for service on January 5th, 2022?
Yes, so I recall getting a call for service early morning hours. And this was for a 911 phone call, and it was for a disturbance in progress.
And did you respond to that call for service?
Yes, myself and numerous officers responded to this call,
I'm sorry, myself and,
and numerous officers.
Would you describe for the jury how you receive calls for service?
Correct. So any call can come in. Many of the calls are coming in from the administration line. They're calling non-emergency. However, a lot of calls are coming in from 911. And those go through a dispatch communication center, and then they cycle the calls depending on the priorities. If it's for medics, fire, police, and then from there they obtain questions, who's calling for what reason, and then they'll start sorting it out. And then they'll dispatch it to an officer over the radio, and then also we'll receive more information by using our computer that is we call it a computer-aided dispatch or mobile data terminal. And that'll have all the details a little bit more so pushed to our computer in our car that we can review as we go to this event.
So you were talking about the information that on the computer. Who receives that information and how is it sent out to your computer?
Right, so it is a software system that obtains quite a bit of everything. It has mapping features. It has the capability of we can run individuals, NCIC, TCIC. It has call notes, and that's kind of the most used thing that we get. So it'll have your initial calling time, who's the caller, who's the alleged victim, suspect, descriptions. It'll have history. If we're going to a certain area and there's history there, it'll have cautions if there's a caution to be careful. So we receive a little bit of everything, and in these kinds of cases, I'm looking at my call notes. So from the minute the dispatch is taking the call, what they start typing in, what is reported, and what's ongoing.
Did you learn anything about this case from your call notes while you were on the way to the call?
Right, so a lot of times we get the initial call over the radio. You may be watching traffic, you may be taking a break, maybe taking a walk. So that initial traffic can sometimes, you feel like you can sometimes miss a bit of it. So it's very important as an officer, you review what's in there. And so it's kind of verbatim for the most part. But like I said, as the call continues or they continue looking into the incident, they may add in more details. So I am able to read the call notes and understand that this is a 911 phone call to a specific address. However, the specific address doesn't have like a unit number, apartment number, trailer number. So I don't know much more about just the block. And it's telling me that somebody's reporting a disturbance in progress.
And the location of that call, is that in Hayes County?
Hayes County within the city limits.
And did you know from the call if the 911 caller was responsive to the operator?
Yes, so kind of understanding what was going on, they explained that it was a disturbance in progress argument, loud argument. They were hearing profanities over the line. And it sounded for sure that the caller was trying to kind of conceal the communication. So they were trying to not make it very 100% aware that they were using a cell phone, but they were in a way trying to ask for help.
Is that kind of 911 call more or less concerning for officers?
More concerning because it means that they're extremely worried that they can't talk freely and very nervous to be doing something like that.
So you responded to the location of the call. You didn't have the exact address. What was your first step when you got to that location?
Right, so this kind of call is very concerning to law enforcement. Not only do we want to get there to make help and immediately control the scene and protect anybody, but we also have to think about everybody else, the public, think about us as we make our approach. So we did position ourselves pretty far away so that way we can get a big picture and see what's going on in that entire area. So I recall this would be in a trailer park. And so that address led us to the entire trailer park at the front. And so from there, we're going to get on foot and start checking the entire area, listening, hearing, seeing, whatever we can find.
Were you able to make contact with the 911 caller?
Yes, we did. It took a bit of a walking through the trailer park. And part of a reason we ended up at the back was what is called a rapid SOS feature. That is a feature that the dispatchers know more about, but they're able to see when a person calls in from a mobile device, a general location. So it'll come to like a latitude, longitude, and they have a Google Maps kind of in there as well. And so one of the things they did tell us was towards the back of the trailer park. And so as we got towards the back of the trailer park, we came across a female walking out towards us.
Who did you make contact with?
So we identified ourselves as police officers and we came across the victim in this case, which was Lauren.
Please describe her demeanor.
So demeanor was pretty shaken up, nervous, amped up, and was seeking help.
Based on your experience, is that common for someone who has just been assaulted?
Yes,
Did you offer to call an ambulance?
correct. So one of our steps is always offering any medical assistance. If they want to get somewhere different, away, we always offer, are you okay? Do you need help? Would you like to see a medic? Always just checking, even if there's no apparent, obvious, immediate sign.
Did Lauren ask for any type of medical assistance?
I recall her kind of denying it, saying she was okay.
Is that normal in this kind of situation?
Yeah, yes.
Let me get the video up for you.
Yes. There. I think I'm looking for.
Officer Gonzalez, I am going to show you what has already been admitted as State's Exhibit 6. And I'm starting defense exhibit 6 at 0 minutes and 0 seconds. I'm actually going to pause it here and I'm going to start at 3 minutes and 34 seconds.
Yes. Okay, so down here. Okay, go in your doctor's chair. You're good, go in your room. What's going on tonight?
We look forward to each other.
Yeah, it's very good. Will you see the beginning of your things? Okay, the end.
Pausing at 4 minutes and 26 seconds. Officer Gonzalez, do you notice anything about her breathing?
Yeah, so she's kind of panting and also crying.
Is that pretty standard?
Yeah, emotional, very much so.
Starting again at 4 minutes and 26 seconds.
No weapons? No weapons, no gun signs? What's the number? It seems to be Jacob, she says no, mention the weapons. Is she okay?
That's why he's trying to do this, and
What's going on with her tonight?
we didn't pursue an argument.
It's not you? Why are you breathing so hard?
So that was.
Yeah, listen, I don't know what you're doing.
We're waiting for we can get a call.
You know, just you're okay. You want to check out the medics? Yeah, just Facebook and for sure. Okay, enough to do healthy now?
Yeah.
Get in front of her tomorrow. Okay. The kids look like that. Let's go back, what you have, put you. Okay.
And pausing at 5 minutes and 21 seconds. Why are you taking Lauren inside?
So I recall this being a pretty cold morning, and also I could tell that her breathing was still she's still trying to catch her breathing, and I felt like that would be a safer environment for her. Either taking her all the way back to the patrol car or back where she's comfortable and cozy in her house.
And we see a bunch of officers on this body cam. Why did so many officers respond to this call for service?
So domestic violence or family violence calls are just inherently more dangerous, risky for officers. We have a higher likelihood of getting assaulted. We're going to somebody's home advantage. Tensions are high, emotions are high. And then we're coming into their crisis to uniform the government and state trying to intervene. So it's a very significant event for the individuals. And in this case, the victim wasn't really able to freely talk in the initial call. And then there was a line that said weapon was mentioned. And so in this case, everybody hearing that, they're gonna make sure we go to be safe.
Do you recognize the name Jacob Kreitzer?
Yes,
If he were in the courtroom today, would you be able to recognize him?
yes,
Is he in the courtroom today?
yes.
Would you please identify him by an article of clothing?
Jacob is wearing a red long sleeve button-up shirt.
And the record reflects that the witness has identified the defendant. Officer Gonzalez, where was the defendant when you first saw him?
Right, so we came across the caller outside, and then we come across the subject involved in the trailer. The trailer they both lived in.
Were there any issues with getting the defendant out of the trailer?
Not at all. Officers there made contact pretty quickly, and he was cooperative and came out.
At this point in y'all's interaction with Lauren, did she say that there had been any physical altercation?
Yeah, so she was pretty forthcoming, saying, yeah, we've been in a situation, and I'm asking her several times if, is there anything significant? Do you need help? Do you need medics? And so from her side, she's saying it's kind of just a push and shove right now. Which she's kind of trying to summarize.
Is it, based on your experience, is it normal or does it happen that a victim would admit to a lesser physical altercation than what actually happened?
Absolutely. In these kinds of cases, everybody's emotional. There's a lot of care, passion. And now that the law enforcement has actually made the scene, they realize that there is consequences, there could be retaliation. And it's hard for them to sometimes get out of that cycle of violence.
I'm gonna move forward to 5 minutes and 34 seconds on defendant exhibit 6.
So, where did all this happen?
In the house.
Yes. I said you just got things?
Oh, yes.
And Officer Neville, I'm pausing at 5 minutes and 46 seconds. You're moving your flashlight to the end of that hall. What does that look like?
So I'm illuminating what appears to be a long rifle. It looks like it has a shorter, smaller, thinner barrel. And just illuminating that to see what that is.
Did you find out what that object was?
I don't remember actually looking at it close up. But from my experience, it kind of just looks more like an air rifle. Or potentially like a 22, something small caliber.
Starting again at 5 minutes and 46 seconds.
So had this happened in your house?
Yes.
What exactly happened?
I don't want to hear me. I really don't.
But we're here to make sure that things be safe, okay? We don't want you to have to be amped up and sorry as much here. Nobody should be going tonight.
I don't like it. It's a baby gun. It's just a baby gun.
Pausing at 6 minutes and 14 seconds. So there, Lauren's saying it's a BB gun. Are BB guns able to cause death?
Not necessarily, it can cause harm.
Starting again at 6 minutes and 14 seconds.
Already, you don't want that attention, you want to show them like that? We're told it's not really my business, so you might, you know, you can kind of put something here.
I just wanted to wait for stuff. That's what we're doing. He assumes I'm cheating on him, but I'm not cheating on him, and I don't know, it just kind of spiraled into something that it didn't spiral into, and I got home and everything was calmed down, came cleaning, and we just had woke up a few minutes ago, I think it got angry, and it escalated into so many things, I was scared and I
You mean stop, what's stopping now, okay? So you said you will help me,
we both kind of
lose each other, good y'all are out there for you. Yeah, we're gonna put in her, you want to check that, there's nothing on your arm, everything okay?
Yeah.
You want to choke that all, right?
Okay.
You want to choke it in place?
Okay.
You okay?
Yeah.
Alright, you're gonna put it in your, get in there, you're gonna talk there right now. We got your information quick, and he's gonna tell us the same thing about what happened.
Probably, yes.
Pausing at 7 minutes and 50 seconds. You asked Lauren if she had been strangled, and her response was okay. Did you take that as a denial?
So I asked her twice and she kind of just was dismissive towards answering directly. And so I felt at that time
That
that
was just speculation.
Sustained.
Based on your training and your experience, how did you take that comment?
that she wasn't being forthcoming about everything.
At any point in your investigation, did you speak with the defendant?
Yes.
What, if anything, did the defendant say about a physical altercation?
He admitted that things got very heated, but he denied anything got out of control physically.
Did he claim at any time that Lauren hit him?
I don't recall.
I am gonna move forward to 9 minutes and 47 seconds. Starting at 9 minutes and 42 seconds.
Is Jacob, that's correct?
I think.
Yeah, yeah. Hey, I'm also a Dolphins fan, so I understand, you're probably explaining to you a little bit what's going on. Go ahead. See, apparently you and your girl are kind of just having a really hard argument, what's going on, like,
Yeah, pretty much, yeah.
she said y'all got back from work or something like that, and then things have just kind of gotten more amped up.
Yeah.
Okay. She told me, she's admitting that you guys are pretty much getting hands on with each other, it's getting to that point where you are getting any physical in each other's face, right? It's getting out of
We're
control.
just getting in each other's face, yeah, but no.
Yeah, it can't get to that point, man. They gotta try to talk it down, communicate. I can't be doing that, right? In the state of Texas, it's considered family violence, any contact, right? Whether it's a shove, push, or assault. That's serious deal, right? A lot of times people go to jail for that kinds of things. What's the big issue tonight, between you guys?
Like I said, just arguing about trust and something like that, you know, stupid little argument.
I just, obviously it's serious though, because y'all are, it's in the middle of the morning, y'all are arguing.
Yeah,
And
well, I
it's
can,
important to call 911, right?
yeah, like I said, we were around, so I'm really,
I got you, man.
good door open.
The biggest thing today is to make sure that this doesn't get out of control. This is our first time here, it's my first time talking to you, but it's obviously, y'all are amped up, y'all are going through a miniature crisis, right? Y'all are going through something serious a lot together. How long have y'all been together, man?
4 years.
4 years now? Okay, and had probably arguments before, but this has probably been a rougher one, right? Because the police are here. I guess she called us and was worried, guess you guys both got into screaming, shouting. At any point in time, did she punch or shove you or choke you, anything like that?
No, there's no like physical things like that, no. It's like I said.
Emotionally.
Yeah, like I have the thing open
Mhm.
and the door open, yeah, and we were yelling at each other, so I understand some of the thoughts, because
Yeah.
we're screaming at each other, so.
Yeah, you're welcome. Are you okay, man? 100%? You're not hurt?
No, I'm good, I'm good.
Um, as far as everything tonight, man, what's the plan? What are you trying to do?
Well, her mom lives right up the street, so she probably gonna stay there, because I know y'all would probably want us, but
It's ultimately the best thing to do, man.
yeah, it's like,
Because everybody got
her mom lives right up there, so.
you're screaming shut in the middle of the morning, right? If y'all need to talk about it, but do it the right way.
Yeah.
Sometimes when you're tired, frustrated at work, and they just say, cut it, man. It's just gonna be more amped up, it's gonna be more yelling, screaming, shouting.
Yeah.
So you didn't get hit or nothing like that?
No, I'm good.
Okay. 100% though? Let me
Yeah,
put
yeah,
it up for me.
the only thing is, this right here, like I said, that's been there, that's a little cut that I had. Like,
Yeah, see, that's what that means.
You can tell, yeah, yeah. Okay.
She's gonna be okay too, man, talking with her?
At 12 minutes and 33 seconds. Officer Gonzalez, may I approach your arm?
May,
I am showing you what has been previously admitted as defendants exhibits 1 through 5. I'm just gonna walk you through them. Do you see any evidence of injury on the defendant's face? And it states in defendant exhibit 1.
The facial, no, we have an injury to the neck.
How about defendant exhibit 2, injury, evidence of any injury?
No.
Not defendant exhibit 3. This defendant exhibit 4, is that just a closer view of the face?
Correct.
Any evidence of injury?
No,
And defendant exhibit 5, what is that?
and that's where I have more of a photo of the neck.
Okay, and the defendant gave an explanation for that. Did he claim in any way that that abrasion or scrape came from Lauren Wilkerson?
No.
Did he give an explanation? It was a couple days old.
Of injury.
May I publish, Judge?
may,
It's taking a long time, I apologize. Officer Gonzalez, while this is loading, I want to talk to you a little bit about your training and experience as a peace officer related to injuries. Do you have, as a peace officer, occasion to see injuries?
I would
Yes.
object to the relevance of this. I don't think it's relevant other than the facts here. I mean, we can talk about what he saw or saw here, but comparing that to other incidents, I do not see the relevance of that.
He would develop his ability to analyze the injuries in this case based on his experience as a peace officer.
Overall,
So, sorry, you have occasion to see injuries
Correct.
on a few or many occasions.
On many occasions.
Are you familiar with the types of injuries that come out of domestic violence situations?
The basic knowledge is what to look for, what to see.
Are you familiar with injuries that can come out of strangulation?
Yes.
Based on your experience, what are some signs of strangulation that you look for as a peace officer responding to these kind of calls?
So for redness and the marks of like the nail when you're trying to get in there. You could have bruising if it's been something that's been older. And any fresh blood, anything around the neck would be an obvious sign something's going on.
So I'm going to show you a couple of images. This has been previously admitted as State's Exhibit 13. What is this? What are we looking at here?
So this will be the victim. And some closer up photos of her.
Okay. Do you notice any signs of strangulation in this picture?
So we'll have a lot of redness around the neck, in the throat area right there.
And you talked about marks from nails or anything like that. Do you notice anything that could potentially be from that?
So you will see like, just looks very irritated right there. It's just uncommon to have that.
And I hate to do this to you. Would you stand up? Actually, I'll come up there. Tell me where to point.
So it'll be,
That up there?
yes,
Okay. So that's, what do you think that is?
we have some fresh marks.
Okay.
Fresh-
Anywhere else on the neck that you're noticing in this
There's
picture?
also a scope down here, but the one that stands out the most is that one.
So we have one here and then up there as well. I don't have a laser pointer. I'm going to show you what has previously been admitted as State's Exhibit 14. Such as a different view of Lauren's neck.
Yes.
And so you're looking at this one over here.
Mhm.
Thank you, Judge. I will actually go. I'll be back here with that. Thank you, Judge. I'm gonna go on this one. Would you point out redness that you see here that could be potential signs of
There is a
strangulation?
longer, right there,
So down here?
right there, yes.
Okay. Anything else on the neck that could potentially be signs?
That's what I'm saying.
Okay. And going to State's Exhibit, thank you, Ally. 15, just another view of the neck.
Correct, and this is the closer photo, so you can see down here, that looks
Just down here.
pretty fresh.
So there's, it looks like there's a couple of lines and then a swab as well.
Right.
We go to State's Exhibit 16. Other side of the neck.
Back to their side.
Do you notice any potential signs of strangulation?
We still have the same as mentioned a while ago, is that one right there on the top?
So a line and a couple of dots?
Yes.
Okay. And State's Exhibit 16? 17, excuse me. Just a different angle, right? Still seeing signs of strangulation?
Yes.
Okay. These are going to be labeled wrong. But gonna show you some pictures of the defendant as well. So these are entered as states exhibit, or excuse me, defense exhibit 1 and defense exhibit 4 on my actual. So unlabeled, but these are gonna be defense exhibit 1. Do you see any signs of injury to the defendant's face?
No,
In defense exhibit 4,
there's like a little bit of dry blood around his mustache right there and on the bottom of the,
okay. Did he admit to anything happening during this altercation?
no, he didn't claim any injuries or needing medicine.
Did he offer any explanation at all regarding any possible thing on his face?
Not the face, only the, what he said was a older injury.
And then I'm going to show you what's been admitted as defendant's exhibit 5. Is this that kind of abrasion on his neck?
Yes,
And he did not say in any way, shape, or form that this came from Lauren Wilkerson.
correct. He claimed it was a prior older injury.
Officer Gonzalez, I'm going to show you some more video. It's been admitted as defense exhibit 7. May I publish, Judge?
Yes.
And Judge, I'm going to show a little longer of a chunk of video. Could we dim the lights?
Side lights are dim.
I am going to be starting at 9 minutes and 32 seconds.
Like the watch these. I don't know about the photo, but
And Officer Gonzalez, we heard Lauren say she doesn't want to get in trouble. Is that consistent with what she said to you earlier?
Correct.
Starting again at 10 minutes and 12 seconds.
And that's what my officer is always saying, it's stop now, so just take a breath. Everything right now is good, we just want to make sure that everyone's all right. So you're saying, I caught a little bit, when you're talking about Officer Gavin, or Officer Gonzalez, that he came home from work and he thought you were cheating on him?
That was while I was at work. Things just kind of, not reading text messages and stuff like that, and I had gotten home finally around like 11:30, and he was asleep, and so I was like, okay, it's kind of summer down and stuff, so I just went to bed to around like 12:30 probably, and then I don't even know what time it is right now, but like as soon as we woke up, just like making the bathroom break, you know what I mean? It just kind of sparkled again, and then I called like 5 or 10 minutes into it. So
And you got what?
I had just called like 5 or 10 minutes into like the argument, because I didn't know what to do at that point. It was really that.
Have y'all argued before, or is it?
We've been together 5 years, so, I mean, like, we had our sit down.
Yeah, like every relationship.
Yeah, everything's been, really good, we, we just.
I mean, yeah, your normal arguments are tend to got pretty heated, some back and forth. Is that something that's happened before too, or?
I've experienced this before, but not for a really long time.
Or what happened I know you said it was a really long time ago. What happened now? It didn't that long ago.
I can't remember.
So anybody like a shoving match, anybody throw punches or?
I mean, to be honest, I did hit him in the face to try and get him away because he kept calling me names and I didn't like it. But he shoved me too, I shoved him too, like, it's all about that.
Stopping at 12 minutes and 18 seconds. It was on both ends, Lauren just said that, still consistent with what she told you at the beginning.
So do you know what happened to your neck here inside?
Probably just from his.
His hand? How was his hand at a car show? Did it choke you? Yeah.
Like a restaurant, I don't want to restaurant.
We want to make sure that living in something that's ongoing, so we want honesty is always the best. We want to make sure that everyone's okay. All right, so.
I did him too.
Well, you think,
Stopping at 12 minutes and 56 seconds, Officer Gonzalez. That kind of explanation, is that common in DV situations?
Yes, there's a lot of care still, even though things have gotten physical. But there's just the thought of the consequences and what has come to the turmoil of this crisis. So,
Starting again at 12 minutes and 56 seconds.
you hit him to get him, because he was calling names or to get off of you?
Because he was calling me names and to get off of me, both of them.
So now that's out there. I know you're saying back and forth and all that, but now that's on the table, because I understand a lot of emotion and everything, but I just, if you need, take a breath by all means, but with that being out there now, some push and shoving, at what point? I just, by all means, take a breath.
Delaying me
And you're all,
and
and it's good that you did. Like, we want to make sure that everyone's safe, okay? Good. Okay, puppy.
I have a game.
So, let's get going now. So. So you were saying, at what point did that happen? I know you said it happened fast, but pushing, shoving. Were you standing, or how did that happen?
Yeah, I think, I don't remember exactly how it happened, but I know we were both standing and, I don't remember who did it first, was the thing.
Okay.
But he kept calling me like a cheater, and I don't like to be called things that I'm not.
Mhm.
And so like I was trying to get him out of my face, and so I'm trying to get him in the face. And like he didn't hit me, but he choked me around the neck, and just like okay, so
One hand, two hands.
I think it was what, I don't remember.
No, it's one of those things that there's definitely a mutual back and forth kind of thing of somebody pushes somebody, that kind of thing, but there's also when it becomes a little out of hand. And choking is one of those things that isn't something that's taken, that's a big thing. So even though you say you slapped him first, right? That doesn't warrant him to choke you. It's not something that's a back and forth. So
It was fine, and I was sleeping, and then like, just woke up in the middle of the night and take the dogs to the bathroom, and it's just like, what? No, why? I just didn't know what to do.
Definitely calling us is definitely the right thing, because we don't want it to escalate to get anything else to happen, right?
Officer Salazar, I'm going to the paperwork, but since you were pretty fresh on the questions and stuff, if you want to cut.
Pause it, 16 minutes and 11 seconds. Officer Gonzalez, based on your training and experience, is strangulation more dangerous than other types of physical assault?
Yes,
Is it, based on your training and experience, is it more deadly?
yes,
Based on your training and experience, is it an escalation?
yes.
When you were speaking with the defendant and with Lauren, did you notice consistencies between their stories?
No,
Okay, did they both say, like in the beginning of their story, did they both say they had arguments, something like that?
yes, that part was consistent. It was the part of the physical contact that was.
So would you say they were consistent and then it diverged at the point where there was a physical argument?
Correct.
At some point, did you make a decision to arrest the defendant?
Yes,
At that time, did you believe you had sufficient credible evidence to arrest the defendant?
yes,
At any point while you were responding to this call, did you consider that the defendant, the male in this relationship, could have been the victim?
correct. Anybody can be a victim, and a lot of times it's hard to be forthcoming when you're emotional, when you care about people. It takes some time to get information out of things and to pay attention to more things. So that's why we're
And-
taking our time. We're never in the business of just taking people to jail right away. There may be a chance to separate them and offer resources, but in this case, we're still investigating, taking our time to look at everything.
And based on your training and experience, is it common for men to be victims of domestic violence?
It can,
And y'all don't treat that any different?
No.
Ask the witness.
Vince? Yes, Your Honor. May I publish, please? Now, you do concede, that Jacob had dry blood on his lips.
yes, sir.
You do concede that Jacob had dry blood around his mouth,
Yes, sir.
or on his mouth, I should say.
Yes,
Based on your training and experience, if somebody comes at you with a gun, you could escalate force, correct?
yes, sir.
Did Ms. Wilkerson ever mention anything about a gun?
Not to us. And when they asked her what that was in the hallway, she mentioned it was a BB gun. She did mention, I guess, in the initial call, something about a weapon.
Okay,
And that's why we kind of had more officers there.
and you're saying it was her that mentioned the weapon?
Yes,
Okay. And that, you're referencing the 911 call?
yes,
Um. And Officer Gonzalez, you also put, in your police report that Jacob had visible redness to the left side of his face.
yes.
Can I get this flipped over to here, or is it already?
It is.
It all is already.
I'm gonna slide it over.
So, Officer Gonzalez, here you have my client under arrest, correct?
Yes, sir.
You're taking him to the county jail, correct?
Yes.
But you explained to Jacob that you're still investigating and talking to Miss Wilkerson, correct? Do you remember, Officer Gonzalez, that you filled out a probable cause arrest affidavit?
Yes.
Did you put anything in that affidavit about my client being hit first?
I don't.
Would it refresh your recollection if I were to show you a copy of that?
Yes, sir.
May I approach Ms. Castillo here, Your Honor?
You may.
Officer, I'm showing you what's been marked as defense exhibit number 10, just for identification purposes. If you could just take a second to look at that. So did you put anything in there about her having struck my client first?
I saw that there's a line that says
What does it say?
she admits to striking him. Just that she's admitted to striking him back in the head.
I'm sorry, sir. Louder for me, please.
There's a line towards my second paragraph that says, it says she admits to striking him back in the head during an altercation. The suspect did have a laceration.
Which means when you write that, you're saying that my client hit her first and that she struck him back, correct?
One more time.
If she struck him back, that's saying that he struck her first, correct?
Correct.
And again, there was no mention in that affidavit about Ms. Wilkerson having struck my client with the gun.
No, sir.
Okay. Now, there was a gun that we could see in this video.
So, where did all this happen?
So we see the BB gun there, right? Is that correct?
Yes,
Okay, but that wasn't in the bedroom, fair to say?
correct. That's in the hallway.
Oh. And it's also fair to say that my client denied having assaulted, Ms. Wilkerson, correct?
Yes.
Also, Ms. Wilkerson denied any sort of medical assistance from EMS.
Yes, sir. Multiple times I asked her, she wanted a medic, she wanted to get us checked on, get assessed. If she was in pain, she denied.
Also in that affidavit, you explained that it was Ms. Wilkerson who mentioned a weapon, fair to say? And that's referring back to the 911 call, correct?
Correct.
And do you know where the bedroom is in relation to that gun?
I'm not 100% familiar with that residence, sir. I mainly stuck to the living room and then keeping them separated in the living room and then outside.
And y'all didn't even take any photos of that gun.
I did not know, sir.
Other questions?
State,
Briefly, Your Honors. Officer Gonzalez, was a gun other than the BB gun that we just saw on video located in the house?
I did not locate it.
Did either party tell you about a firearm other than the BB gun and being in the house?
No, when we're on scene there, there's no other mention or interview statements about it, anything.
Is that something that officers would look for in this type of situation?
We're not necessarily searching for a weapon in somebody's house unless it's immediately known that it was used in the crime.
Did anyone report to you, the victim or the defendant, that anyone had been struck with a weapon?
No.
And when we're talking about the 911 call, and you're writing the PCF data, and you're deciding whether to take the defendant into under arrest, do you listen to the 911 call prior to that decision?
No.
Do you listen to the 911 call as you're approaching the residence?
We don't get to my own call.
So all information that you know about the 911 call, where does that come from?
The dispatch center, there's a call taker that takes in the initial call, is listening, typing in notes. The call taker passes it to the radio operator, who then transfers it, airing out the radio traffic and making sure the system has all the updates.
So there was just a note, gun on.
Potential weapon
something like
involved.
that. And would would the victim slapping the defendant first in any way invalidate an arrest for an impeding?
No.
Why?
It's just a regular strike.
Is impeding a greater degree of violence than a slap?
Correct.
Pass witness.
Officer Gonzalez, if somebody comes at you with a gun, and you respond by, throwing against the wall and impeding, is that proper self-defense?
If someone has a weapon, it's a deadly situation.
Right. No further questions, Your Honor.
Just to clarify, is a BB gun a deadly weapon?
No.
No further question.
Um, that BB gun is made of metal, correct?
Yes.
It could be employed as a deadly weapon, correct? If you're using it to hit somebody's head, for example?
Yes, sir. It could be a blunt force instrument.
Right. Or if it's loaded and you're firing BB gun shots at somebody?
It could cause harm, correct?
No further questions, Your Honor.
May this witness be excused?
Yes, Your Honor.
Defense?
Yes, sir.
Thank you, sir. You're free to go about your business.
Thank you, Judge.
State, call your next witness.
State rest, Judge.
All right. Defense?
Congrats, Judge.
All right. Ladies and gentlemen, you've heard all the evidence that you will hear in this case. What we will do now is take a break. We will finalize the jury charge for you. That's the law of the case that you will hear. We'll come back in. I will read that to you, and the attorneys will give you their closing arguments. Remember my instructions. Don't start talking about this case yet. You won't talk about the case until all 12 of you are together and you are deliberating. Don't text about it, tweet about it. Don't put anything on social media. Don't try to look up anything on the internet. We will take about a 15 to 20 minute break and come back in and get started with that next phase. Thank you very much.
All right, for the jury.
Ruby, can we go and stay on the record? Yes, sir. All right, we have last night given you the jury charge. Are there any objections to the jury charge from the state,
No objection from the state.
from the defense?
No, Your Honor.
All right. Given the amount of time of this, I'm thinking 20 minutes for closing arguments each side. Good state,
I think that's fair, Judge.
defense?
That'd be fine, Judge. Do you mind, just because of the timing of what I have to do you mind like appointing Todd Dudley just to hang around and handle, this, because I probably gotta leave at 12. We've got plenty of time to do everything, just to get the verdict and all that stuff.
And does he need to be appointed for that?
No, I mean,
Well, let's talk about, we can go off the record. You may be seated. I will now read you the charge of the court. Ladies and gentlemen of the jury, the defendant, Jacob Paul Kreitzer, is charged with assault under section 22.01 B2B of the Texas Penal Code. To this offense, the defendant has pleaded not guilty. Both sides will soon present final arguments. Before they do, I must give you the instructions that you must follow in your deliberations. First, I will tell you some general principles of the law that must govern your decision of the case. Then, I will tell you about the specific law applicable to the case. Finally, I will instruct you on the rules that must control your deliberations. General principles. The indictment. The indictment is not evidence of guilt. The indictment is only a document required to bring the case before you. The indictment cannot be considered in any way by the jury. Do not consider the fact that the defendant has been arrested, confined, indicted, or otherwise charged. Presumption of innocence. All persons are presumed to be innocent. No person may be convicted of an offense unless each element of the offense is proved beyond a reasonable doubt. The law does not require a defendant to prove his innocence or produce any evidence at all. Unless the jurors are satisfied beyond a reasonable doubt of the defendant's guilt, after careful and impartial consideration of all the evidence in the case, the presumption of innocence alone is sufficient to acquit the defendant. Burden of proof. The prosecution has the burden of proving the defendant guilty. It must do so by proving each and every element of the offense charged beyond a reasonable doubt. If it fails to do so, you must acquit the defendant. It is not required that the prosecution prove guilt beyond all possible doubt. It is required that the prosecution's proof excludes all reasonable doubt concerning the defendant's guilt. If the state proves every element beyond a reasonable doubt, then you must find the defendant guilty. In the event you have a reasonable doubt as to the defendant's guilt after considering all the evidence before you and these instructions, you will acquit him and say by your verdict, not guilty. Jury is fact finder. You are the exclusive judges of the facts proved, of the credibility of the witnesses, and of the weight to be given to the testimony. In judging the facts and believability of the witnesses, you must apply the law provided in these instructions. Evidence. The evidence consists of the testimony and exhibits admitted in the trial. You must consider only evidence to reach your decision. You must not consider, discuss, or mention anything that is not evidence in the trial. You must not consider or mention any personal knowledge or information you may have about any fact or person connected with this case that is not evidence in the trial. Statements made by the attorneys are not evidence. The questions asked by the attorneys are not evidence. Evidence consists of the testimony of the witnesses and the materials admitted into evidence. You are instructed not to allow yourselves to be influenced by what you may think is the court's opinion in this case. The court has no right, by word or act, to indicate any opinion regarding any matter of fact involved in this case, nor whether the defendant is guilty or not guilty. The court has not intended to express any such opinion. If you have observed anything which you have interpreted or may interpret as the court's opinion upon any matter of fact in this case, or of whether the defendant is guilty or not guilty, you must disregard it. You should give terms their common meanings, unless you have been told in these instructions that the terms are given special meanings. In that case, you should give those terms the meanings provided in these instructions. While you should consider only the evidence, you are permitted to draw reasonable inferences from the testimony and exhibits that are justified in the light of common experience. You may make deductions and reach conclusions that reason and common sense lead you to draw from the facts of the evidence. Admitted exhibits. The admitted exhibits will be provided to you for your deliberations. Only exhibits that were admitted into evidence may be given to you. Written or recorded statements made by a witness to investigators or other officers, or police reports made by officers and tendered by the prosecution to the defense for purposes of cross-examination are not part of the evidence unless introduced in evidence. Testimony. The court will allow testimony to be read back to the jury only if the jury, in a writing signed by the foreperson, 1, states that it is requesting that testimony be read back. 2, states that it has a disagreement about a specific statement of a witness or a particular point in dispute. And 3, identifies the name of the witness who made the statement. The court will then have the court reporter read back only that part of the statement that is in disagreement. Defendant's right to remain silent. Our law provides a defendant may testify in his own behalf if he elects to do so. However, this is a right accorded to a defendant. If he elects not to testify, that fact cannot be taken as a circumstance against him during your deliberations. In this case, the defendant has elected not to testify. You are instructed that you cannot and must not refer or allude to that fact throughout your deliberations. You must not speculate, guess, or even talk about what the defendant might have said if he had taken the witness stand. The foreperson of the jury must immediately stop any juror from mentioning the defendant's decision not to testify. Other acts. During the trial, you heard evidence that the defendant may have committed wrongful acts not charged in the indictment. You are not to consider evidence of such wrongful act at all unless you find beyond a reasonable doubt that the defendant did in fact commit the wrongful act. Those of you who believe the defendant did the wrongful act may consider it. You may not use this evidence to prove that the defendant is a bad person and for this reason was likely to commit the charged offense. Note taking. You have been permitted to take notes during the testimony in this case. In the event any of you took notes, the bailiff will collect those notes prior to deliberations. You may not rely on your notes during your deliberations. Law. 1. Our law provides that a person commits the offense of assault under section 22.1 B2B if he intentionally, knowingly, or recklessly causes bodily injury to another who is a member of the defendant's family, member of the defendant's household, or person with whom the defendant has had a dating relationship, by intentionally, knowingly, or recklessly impeding the normal breathing or circulation of the blood of the person by applying pressure to the person's throat or neck, or by blocking the other person's nose or mouth. 2. Bodily injury means physical pain, illness, or any impairment of physical condition. Household means a unit composed of persons living together in the same dwelling without regard to whether they are related to each other. 3. A person acts intentionally or with intent with respect to the results of his conduct when it is his conscious objective or desire to cause the result. A person acts knowingly or with knowledge with respect to the result of his conduct when he is aware that his conduct is reasonably certain to cause the result. A person acts recklessly or is reckless with respect to the circumstances surrounding his conduct or the result of his conduct when he is aware but consciously disregards a substantial and unjustifiable risk that the circumstances exist or the result will occur. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the actor's standpoint. 4, you are instructed that under our law, voluntary intoxication, if any, does not constitute a defense to the commission of a crime. For the purpose of this law, intoxication means a disturbance or mental or physical capacity resulting from the voluntary introduction of any substance into the body. Five, now, if you find from the evidence beyond a reasonable doubt that on or about the 5th day of January, 2022, in Hayes County, Texas, the defendant, Jacob Paul Kreitzer, did then and there intentionally, knowingly, or recklessly cause bodily injury to Lauren Wilkerson by intentionally, knowingly, or recklessly impeding the normal breathing or circulation of the blood of Lauren Wilkerson by applying pressure to the throat or neck or by blocking the nose or mouth of Lauren Wilkerson, and Lauren Wilkerson was a member of Jacob Paul Kreitzer's household, or Lauren Wilkerson had a dating relationship with Jacob Paul Kreitzer, then you will next consider whether the defendant did so in self-defense, as just instructed in paragraphs 6 through 7. If you do not so find from the evidence beyond a reasonable doubt, or if you have a reasonable doubt thereof, you will find the defendant not guilty, and you will not consider paragraphs 6 and 7. Paragraph 6. A person is justified in using force against another when and to the degree he reasonably believes the force is immediately necessary to protect himself against the other's use or attempted use of unlawful force. A person is justified in using deadly force against another, 1, if the person would be justified in using force against the other in the first place, as set out above, and 2, when and to the degree the person reasonably believes the deadly force is immediately necessary to protect himself against the other's use or attempted use of unlawful deadly force. The use of force against another is not justified in response to verbal provocation alone. Reasonable belief means a belief that would be held by an ordinary and prudent person in the same circumstances as the defendant. Deadly force means force that is intended or known by the person using it to cause, or in the manner of its use or intended use, is capable of causing death or serious bodily injury. Bodily injury, as defined in paragraph 2, applies and has the same meaning here. Serious bodily injury means bodily injury that creates a substantial risk of death or that causes death, serious permanent disfigurement, or protracted loss or impairment of the function of any bodily member or organ. A person, 1, who has a right to be present at the location where the deadly force is used, and 2, who has not provoked the person against whom the deadly force is used, and 3, who is not engaged in criminal activity at the time the deadly force is used, is not required to retreat before using deadly force. If all 3 of these factors are met, then in determining whether such actor reasonably believed that the use of force was necessary, a finder of fact may not consider whether the actor failed to retreat. The defendant is not required to prove that his use of force or deadly force was justified. The state must prove beyond a reasonable doubt that the defendant's use of force or deadly force was not justified. Paragraph 7. Now, keeping in mind these instructions, even if you unanimously find that the state has proven beyond a reasonable doubt that the defendant, Jacob Paul Kreitzer, committed the offense of assault under section 22.1B2B against Lauren Wilkerson, you must next decide whether the state has proven beyond a reasonable doubt that the conduct was not justified. Therefore, if you find from the evidence beyond a reasonable doubt that the defendant, Jacob Paul Kreitzer, did commit the offense of assault under section 22.1B2B against Lauren Wilkerson, as instructed in paragraph 4, but you further find from the evidence that, or you have a reasonable doubt as to whether at the time he did so, 1, Jacob Paul Kreitzer reasonably believed that Lauren Wilkerson was using or attempting to use unlawful force or deadly force against Jacob Paul Kreitzer, and 2, Jacob Paul Kreitzer reasonably believed that his use of force or deadly force and the degree of force or deadly force used were immediately necessary to protect himself against Lauren Wilkerson's use or attempted use of unlawful force or deadly force, if any. And 3, Jacob Paul Kreitzer's use of force or deadly force was not in response to verbal provocation alone. Then you will acquit the defendant and say by your verdict, not guilty. However, if you find from the evidence beyond a reasonable doubt that the defendant, Jacob Paul Kreitzer, did commit the offense of assault under section 22.1B2B against Lauren Wilkerson, as charged in the indictment, and you further find from the evidence beyond a reasonable doubt that 1, Jacob Paul Kreitzer did not reasonably believe that Lauren Wilkerson was using or attempting to use unlawful force or deadly force, if any, against Jacob Paul Kreitzer. Or 2, Jacob Paul Kreitzer did not reasonably believe that his use of force or deadly force and the degree of force or deadly force used were immediately necessary to protect himself against Lauren Wilkerson's use or attempted use of unlawful force or deadly force, if any. Or 3, Jacob Paul Kreitzer's use of force or deadly force was in response to verbal provocation alone. Then you will find against the defendant on the issue of justification and render a verdict of guilty of assault under section 22.1B2B as charged in the indictment. Rules that control your deliberations. You must follow these rules while you are deliberating and until you reach a verdict. After the closing arguments by the attorneys, you will go into the jury room. Your first task will be to pick your foreperson. The foreperson should conduct the deliberations in an orderly way. Each juror has 1 vote, including the foreperson. The foreperson must supervise the voting, vote with other members on the verdict, and sign the verdict sheet. You must communicate with the judge only in writing, signed by the foreperson and given to the judge through the officer assigned to you. You must not conduct any independent investigations, research, or experiments. Do not look up any words. Do not post information about the case on the internet. Do not share any special knowledge or experiences with other jurors. Your sole duty at this point is to determine whether the defendant has been proven guilty. You must restrict your deliberations to this matter. You are not to let bias, prejudice, or sympathy play any part in reaching a verdict in this case. To return a verdict, each juror must agree to that verdict, but jurors have a duty to consult each other and to deliberate with a view to reaching unanimous agreement. if that can be done without violence to individual judgment. During deliberations, a juror should not hesitate to re-examine his own views and change his opinion if convinced it is erroneous. However, no juror should surrender his honest conviction as to the weight or effect of the evidence solely because of the opinion of his fellow jurors or for the mere purpose of returning a verdict. After you have arrived at your verdict, you may use the form attached to these instructions. You should have your foreperson sign his or her name to the appropriate verdict. After the closing arguments by the attorneys, you will begin your deliberations to decide your verdict. Signed by me, Tanner Neidhardt, 43rd Judicial District Court, Hays County, Texas. And the verdict of the jury reads, we, the jury, unanimously find the defendant, Jacob Paul Kreitzer, guilty of the offense of assault under section 22.01 B2B as charged in the indictment. If that is your verdict, the foreperson will sign that line. Or we, the jury, unanimously find the defendant, Jacob Paul Kreitzer, not guilty. If that is your verdict, the foreperson will sign that line. State, are you ready to give your closing argument?
Yes, Your Honor.
You may proceed.
Could we have the cameras back up?
Yes, ma'am.
Is
I'm about to.
is it?
It's about to be. I'm clipping it before, so I don't chew with all the
Thank you.
reverb. Lauren Wilkerson opened her eyes. She saw black. She could feel the defendant's hands, or hands around her neck. She was on her back on the ground. She had already been strangled that night. She opened her eyes and she saw black. It was scary and it hurt. It wasn't the first time she'd been strangled that night. You're here on assault and violence and beating. You'll heard the elements from the judge. Have them for you here. Most of these aren't disputed. The date, January 5th, 2022, not disputed. Location, Hays County, not disputed. Identity of the defendant, not disputed. Even the fact that he intentionally, knowingly, recklessly caused bodily injury by impeding her normal breathing or circulation of the blood, or by applying pressure, or by blocking her nose and throat, is not really disputed. That's not what we're here about. I'm gonna get into some stuff with you. First thing I want to get into with y'all, inconsistencies. I put it in quotes for a reason. Lauren did something really hard this week. She got on the stand and she opened herself up to a lot of argument from the defense counsel. And the defense counsel would ask her, did you say this? Do you remember saying it? And she would say, I don't remember saying that. No, I don't think I said that. And we would pull up a 4-second clip on a body cam of a police officer from 3 years ago, play it for her, and just look at her. Lauren wasn't lying at any point. This happened 3 years ago. She doesn't remember the 4-word sentence she said to 5 different police officers. That's normal. If any of us were held to the standard of a defense attorney and find Lauren be held to, we would all fail. The inconsistencies that he's going to point out do not hold water. I'm going to talk to you about the consistencies because Lauren was consistent. We know that on January 4th, 2022, Lauren was working a normal shift at Chili's. The defendant was blowing up her phone with texts accusing her of cheating. It wasn't the first time he had done that. She got home late that night. Chili's closed around 11:30. The defendant was already asleep. She stayed up for a little bit, then she went to bed. They woke up a couple hours later because they had new puppies, needed to go to the bathroom. The defendant said something along the lines of, "Baby, are we okay? Are we okay, baby?" And Lauren, talking to her boyfriend of 4 or 5 years, as you do with a partner who you've been with for that long and you've lived with for that long, said jokingly, "Yeah, you just have a lot of apologizing to tomorrow." Defendant did not like that. We know that. You can hear it on the 911 call, and you can see it in the scratches on her neck and in the bruise on her leg. Verbal argument started after that comment, shouting, screaming, name calling, and it turned physical. Lauren admits to pushing, shoving, even hitting the defendant to get him away from her because she was scared of him. The defendant strangled Lauren 4 different times. We know the locations of 3. The fact that we don't really know the 4th, that's not an issue here because we heard in jury selection, we all agreed fragmented or incomplete memories out of an issue like this, out of an event like this, where someone is cutting off the blood flow and you can't breathe, is normal. But Lauren is consistent, has been consistent every time she's talked about those 3 locations. And we know why she didn't say to the officers, "He strangled me, it was one big event, but it was really 3 different times," right? She viewed it as one, and it was broken down. We broke it down deeper into the different elements, the different times of strangulation. He strangled her on the bed, on the bathroom, against the bathroom door, and on the floor. When they were on the floor, after she had already been strangled several times, Lauren was reaching around, grabbed a paddle to try to hit the defendant off of her. He took that paddle and struck her with it hard enough to leave deep blue bruises on her leg. He strangled her on the bed, a little bit of blood on the bed. He strangled her against that door and in front of it on the floor. He put marks on her neck. He put a lot of marks on her neck. And he put a bruise on her leg. We talked about in jury selection the possible signs of impeding or strangulation. You've all seen this slide before. Difficulty breathing, speaking, swallowing, nausea, vomiting, lightheadedness, headache, bruising, redness, scratches, and loss of memory. Y'all remember that slide? We've got 3 to 4 here. We have difficulty breathing. You can hear it on the body cam. She has difficulty speaking. She has bruising, redness, and scratches on her neck. That's not in dispute. You can see it in the photos. And we have loss of memory. We also know that Lauren called 911 and was afraid to talk to the 911 operator. She was afraid because the defendant was still screaming at her. She had been strangled 4 times, and the defendant was still screaming at her. She was scared. She called for help. She didn't think she could talk to the operator, so she put it in her pocket. And when you listen to the 911 call, I know we've heard it a couple times, she is begging him to calm down. She is begging him not to choose violence. She is asking him to walk away. And you can hear the anger in the defendant's voice. Because he's not going to do that. He didn't do it a single time that night. We also know that when officers arrived, Lauren initially denied the defendant was the aggressor. We talked about the cycle of violence in jury selection, and you saw a almost perfect example of it on the stand before. She talked about how this had happened before. Maybe it wasn't a completely physically abusive relationship, but she talked about how the defendant was good, and at the drop of a hat, he was bad. She talked about how she stayed with the defendant because she knew how good he could be. She knew what their relationship could be. And that when she initially talked to officers, she had that in mind. She didn't have any intention to break up with the defendant on this day. She initially denied it. She said they were mutual aggressors. She didn't tell them about the strangulation. It was once she felt safe, the defendant was outside, and she was surrounded by police officers, that she told officers the truth. We also know that the defendant denied that anything physical happened that night. He didn't claim that she hit him with a weapon, of which there were none in the house found, other than a BB gun that was his and he'd gotten as a Christmas present. He never said she hit me first, and he never said she tried to kill me. He denied anything physical happened. When officers noted a mark on his neck and possibly some blood on his lip, he again said, nothing happened. This mark on my neck happened a couple days ago. It has nothing to do with what happened today. That was the time to tell officers she tried to kill me. She came at me with a metal BB gun, swung it at my head, and I had to strangle her 4 different times to get her to stop. And he didn't do that. Because that's not what happened. Even when he was arrested, he never made that allegation. Here's an interesting thing today. To find a guilty verdict, you only have to believe that Warren was strangled a single time. We provided evidence he was strangled 4 times. You only have to believe 1. And all of you only have to believe 1, and you don't have to believe it was the same one. 3 of you can believe the strangulation on the bed. 3 of you can believe the strangulation against the door. The rest of you can believe the strangulation against the on the floor. And as long as all of you believe that she was strangled 1 time, we get a guilty verdict. You can all believe that she was strangled all 4 times. We have provided evidence of that. We have provided sufficient testimony to that, but you don't have to. Talk about self-defense a little bit. Person is justified, this is in the jury charge also. A person is justified in using force against another when and to the degree he reasonably believes the force is immediately necessary to protect himself against the other's use or attempted use of lawful force. To the degree is highlighted. Why did I highlight that? Bolded, excuse me. Because strangling someone is deadly. It is not a reasonable use of force in response to some slaps. And I want you to remember, Lauren said she minded. Open hand slap, front of face, back of head, front of face. That is what she said. And in response to that, the defendant wrapped his hands around her neck. It is not a use of force that is proportionate to what he's faced. Deadly force, strangulation is deadly force. Means force that in the manner of its use is capable of causing death or serious bodily injury. When we talked about impeding in voir dire, one of the first things that one of your fellow panel members said, deadly. You can die really fast from getting choked. The neck is a sensitive area. It is delicate. The defendant used deadly force against Lauren Wilkerson on January 5th, 2022. A person is justified in using deadly force against another when and to the degree the actor reasonably believes the deadly force is immediately necessary to protect the actor against the other's use or attempted use of unlawful deadly force. At no time in this interaction did Lauren attempt to use deadly force against the defendant. She grabbed a paddle to try to hit him. She used the BB gun to push him away. At no point did she swing it at him. And at no point did she do anything else that would put the defendant in fear of his life. Reasonable belief means a belief that an ordinary and prudent person would have held in the same circumstances as the defendant. Y'all all saw the size discrepancy between Lauren and the defendant. Lauren's little. She's small. Under the same or similar circumstances of being slapped, open hand slapped on the head, maybe pushed, shoved, it is not reasonable to wrap your hands around that person's throat, put them on the bed, put them against the wall, and put them on the ground. Immediately necessary. It wasn't immediately necessary. Lauren, it was a verbal argument, getting in each other's faces. Pushing, shoving, nothing major. The small slaps. The defendant was not in danger. He did not need to wrap his hands around her neck. A 5'1" girl that he had been dating for 4 to 5 years, that he lived with for 4 to 5 years, that he shared 3 dogs with. He knew her. He knows what she's capable of. It was not immediately necessary for him to wrap his hands around her neck. The state has proved beyond a reasonable doubt every element of assault, family violence, and beating 4 times over. You all only have to believe in one, but we proved it 4 times. And the defendant did not need to use deadly force against his girlfriend for 4 to 5 years. It was an escalation. And you don't get to escalate a fight with your girlfriend into something that could kill her.
You have 517 remaining. Vince, you may proceed.
Thank you, Your Honor. May it please the court.
Make sure you put that on.
Mr. Kreitzer, Ms. Smith, Ms. Booth. I think this case is exactly what I told you it would be about in the beginning. The law is not misogynistic. Jacob classically acted in self-defense when Lauren, the aggressor, self-admittedly hit him first and came after him with a gun. Do not lose the privilege of self-defense for yourself, your family, your neighbors, and the community. We wouldn't be here if this was between 2 men or 2 women. Don't forget that we all have fathers, sons, and brothers, and husbands. I briefly want to go over the jury instructions with you. We discussed the right to remain silent. That's on pages 4 and 5 of the jury instructions. We also discussed how the state is required to prove beyond a reasonable doubt that self-defense is not applicable. It says here the defendant is not required to prove the use of force or deadly force was justified. The state must prove beyond a reasonable doubt that the defendant's use of force or deadly force was not justified. A conviction may only be had if the state can prove to you their case beyond a reasonable doubt. Remember back in jury selection, we talked about wrongful convictions. Everybody here agreed that wrongful convictions occur. Enforcement of this burden of proof beyond a reasonable doubt is how we prevent wrongful convictions. Remember back in jury selection, we also discussed, what if I'm the state and I'm trying to involuntarily commit you to a mental institution or take your child away from you. On a scale of 1 to 10, everybody said they 1 to 10. And that is under a clear, convincing evidentiary standard, which is a lower burden of proof beyond a reasonable doubt. Deliver your verdict with a clear conscience. How do you deliver your verdict with a clear conscience? You deliver your verdict with a clear conscience by enforcing that burden of proof beyond a reasonable doubt. It's justice, because it's the law. What does it feel like? Well, we talked about maybe you lock the door, you forget to check the handle, you drive off, you might have a nagging feeling. If you have any sort of nagging feeling, then you do not have proof beyond a reasonable doubt. Finally, I want to take on this notion that it must be true because the state says so, or why else would they be investing all this time, money, and resources? Well, that comes with a very faulty assumption that the state is altruistic, that the state is selfless. But no, they have motives. Their motives are to justify the arrest, the motives to justify the filing of the indictment. The state is a plaintiff. They filed a criminal lawsuit against Jacob. The judge told you that that indictment is what brought Jacob to court. That's a lawsuit. Jacob's not on trial, the state is on trial. The state is on trial because they filed a lawsuit, they are a plaintiff, and therefore they have the burden of proof beyond a reasonable doubt. The burden for the plaintiff is a very high burden. It's a very high burden because the very principles upon which this republic were founded upon are at stake. Life, liberty, and the pursuit of happiness. I want to go back to the jury charge. Page 8, under paragraph 6, basically discusses self-defense. And notice with self-defense, there's no misogynism in that. It's 100% gender neutral. It also discusses how the use of force against another is not justified in response to verbal provocation alone. Page 9 discusses generally that there's no duty to retreat. Again, there's no misogynism in this. It's gender neutral. In discussing proof beyond a reasonable doubt the state has, there's no misogynism in that either. It's gender neutral. They've both been drinking. Jacob had been drinking whiskey, and the aggressor had been drinking nearly a whole bottle of wine and shot at minimum. Now, she testified to you that she maybe had one drink, and then she drank the whole bottle. That was great right then and there. We know that because it's at the top of the trash can. Jacob is heated, but verbal provocation alone doesn't allow the aggressor to result to family violence. And of course he's heated. She came at him with the gun. She admitted she had the gun, but she can be blacked out. She can't tell you how she came at him with the gun because she came at him with the gun. So of course Jacob is upset on that 911 call. Anybody would be a tad bit upset if somebody comes at you with a gun. An argument from the aggressor that arguing allows a person to resort to family violence is utterly ridiculous. Because if you say that an argument is about to go ahead and attack somebody, that means that a partner would be justified in attacking another partner. This logic would condone family violence. And family violence is not okay, period. The aggressor admitted that the aggressor hit Jacob in the face to try to get him away because Jacob kept calling the aggressor names, and the aggressor didn't like it. Again, words alone do not justify family violence. Specifically, Officer T. Scott even asked her, "It looks like you hit him to get him off you." So he's planting the answer into her mouth. And she replies, "I hit him because he kept calling me names, and I didn't like being called something I wasn't." The aggressor employed family violence because of verbal provocation alone. The aggressor admitted they were both pushing each other. The aggressor popped him in the mouth. She didn't just slap him. At some point, she had to have popped him in the mouth. We know that because of the dry blood that is on Jacob's lips and around his mouth. Notice that the aggressor's taping of that 911 call was in secret. She knew that that call was being placed. Jacob did not. Jacob said, I can call you names because you effing hit me. You hit me and made me bleed, so I'm allowed to call you whatever the F. She replied, you made me bleed too, and you effing choked me and threw me against the wall in the ground. Jacob replied, you came with a weapon and a gun. You effing idiot. Yes, you do. On my head. So you're damn right that Jacob responded by disarming her. He responded by disarming her by throwing her against the wall and choking her for 3 seconds in order to get a deadly weapon out of her hand. His life was on the line. He neutralized a deadly threat. He choked her. Do I like that? Do I like the fact that he choked her? Hell no. I don't like the fact that he choked her. But our feelings don't make something illegal. We all agree that self-defense is a vital privilege. That's why I assume most of us have guns in our houses. Ladies and gentlemen, self-defense is not pretty. It can lead to death. It can lead to serious bodily injury. It can lead to mayhem. All of which didn't happen here. The aggressor largely escaped from this situation unscathed. She didn't even have to go and seek medical assistance. She came at Jacob with a gun. She didn't tell the cops about that gun because she came at Jacob with a gun. He could have killed her. But all he did was throw her against the wall and choke her for 3 seconds. I call self-defense the 3 I's. Person is the impetus, they interject upon you, and they involuntarily place you into a dangerous situation. The state wants you to Monday morning quarterback this whole situation in the aggressor's favor. In a moment, you're going to retire and deliberate and reach a verdict. Y'all are going to get to go back there and calmly and coolly think and reflect. Jacob didn't have that privilege. Jacob didn't have the privilege to calmly and coolly think and reflect. He was involuntarily placed into a life and death situation. He had to use his instincts to survive. What would you have Jacob do? What does he do? Just coming at him with a gun. Does he just stand there and get his ass kicked? Does he just stand there and get shot by the aggressor? Does he run? Does he retreat? The law doesn't require that. Can you outrun a bullet? The bottom line is that Jacob used justified force to disarm the aggressor. Don't forget, he could have justifiably killed her. Don't you see why the aggressor told the police she didn't want to press charges? She knew what she had done. Now, in support of its indictment, the state makes false arguments. False argument number 1 is this stuff about the bed choking. Well, she never told the police that. This is the first time that we're hearing this here at trial. And that's because the aggressor had heard that 911 call and she had to justify her going to get that gun. Remember, she didn't tell the police whatsoever that she got a gun. This is called revisionism. The state knows that Jacob threw her against the wall and choked her to disarm her. False argument number 2. Jacob's statement is indicative of guilt. Jacob lied. Unquestionably, he lied to the police. He was lying to the police to protect her. He didn't say anything to the police about the gun, but he said it when he knew that he wasn't being taped. He didn't want her to get arrested. He's got multiple markings all over him. He's got blood on his mouth. And instead, because he lied, he was the one that got arrested. False argument number 3. Only Jacob was arguing and heated. No, the aggressor was heated too. Remember, you have that 911 tape. She knows that she's being taped. Jacob doesn't know that he's being taped. Of course, she's going to temper down what she's doing a bit. But still, she still said F you on that 911 call. Also, why wouldn't Jacob be a little bit heated? Anybody would be heated if somebody came after them with a gun. False argument number 4. Jacob did not act in self-defense. Fact, the aggressor hit Jacob first. Fact, they started pushing each other. Fact, she went for a gun. Fact, Jacob disarmed her by throwing her against the wall and choking her. For 3 seconds, she admits that's what she told the cops. 3 seconds, not 10 seconds. 3. He neutralized the situation. The aggressor came out unscathed, even though she hit Jacob first, even though she went after a gun. False argument number 5. Law enforcement did a good investigation. That officer said on the video, whenever there's strangulation, somebody's going to jail. That officer wasn't even considering whether Jacob had acted in self-defense, just like Ms. Smith hasn't considered if Jacob acted in self-defense. She told you, either back in board eye or open, there's only 3 elements to consider. She never told you you got to consider self-defense. They never considered self-defense whatsoever. They arrested him while they're still investigating. The officer Gonzalez admitted that as they're driving him to the Hayes County Jail, they're still talking to the aggressor and investigating, but they've already placed him under arrest. They've already made their decision. And what about this arrest affidavit? He says that my client hit her first in that arrest affidavit. He never mentions that Jacob was the one who was hit first. You know what else was interesting? The aggressor told the cops, we've hit each other before a couple of times. Mostly it was me. I do not think that you'll need to go back and look at the videos, but if you feel you do to reach a verdict, go back there and do it. But if you so choose to do so, you're going to look at Officer M. Theron's body cam, and you're going to look about 26 to 27 minutes. And that's where she makes that statement. Subsequently to making that statement, she's asked, how many times prior did he get physical? She responded, maybe just once. So yeah, there's a cycle of violence. There's a cycle of violence from the aggressor. Jacob did not commit this crime. Jacob is innocent. Don't let the DA's office impinge on our fathers, our husbands, our brothers, and our sons' privilege to self-defense. Render a verdict of not guilty. Thank you.
Okay, any rebuttal?
Yes, Your Honor.
May proceed.
Y'all have seen this slide before too, beyond a reasonable doubt. It's not hard. Do I have a doubt? Is it reasonable? It doesn't go to an element of the offense. You can have doubts about things. To get a verdict of not guilty, it has to go to something in the offense. There's not reasonable doubt here. To believe in the defendant's self-defense claim, you have to believe that he was allowed to use deadly force in response to force from the victim, from Lauren, every single time he put his hands around her neck.
I would object to misstating the law on the charge, says force or deadly.
Sustain.
Force or deadly force. That means that you have to believe he was reasonable in doing so. The first time he choked her out on the bed. That after she's been choked out on the bed and had her breathing impaired, that it was then reasonable of him to do the same thing against the bathroom door. In that it was then reasonable again, after choking her already, impairing her breathing, hurting her, to put his hands around her neck, get her on the ground, squeeze her enough that she couldn't breathe and her eyesight went black. That's what you have to believe for a self-defense claim in this case. And it's not reasonable. I want to talk about the 911 call. Defense counsel believes that Lauren Wilkerson somehow, after being assaulted in his opinion, setting up the defendant in all these different ways, that she thought to herself, I'm gonna call 911, I'm gonna make it a secret, I'm gonna put it in my pocket, I'm gonna frame the defendant. That is an unreasonable thing to believe. The 911 call is not chronological. It's not a chronological rendition of what happened. Lauren does not say, we woke up, I slapped you, you choked me once, you choked me twice, you choked me another time, you choked me a fourth time, and then blah, 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 blah. She doesn't say that. She says she was choked once. If she was framing the defendant, don't you think she would have done a better job? I mean, she did a bad job of this because that was not what she was doing. She was scared, she was hurt, she was scared for her life, and she was calling for help, and she was hoping that the police would be able to get her location. That's what happened. Again, defendant is the aggressor in the 911 call. When y'all listen to it, you're gonna hear him shouting about the last 3 weeks. You've been abusing me the last 3 weeks. Lauren testified she was not mean, she was not cruel, there was violence within the past 3 weeks. They were in a rough spot in their relationship. He was mad about that. That's what he was mad about on January 5th, 2022. She wasn't doing what he wanted. She said a glib comment meant to be a joke. And he was already mad at her for 3 weeks before that. And so he choked her. There are consistencies in the 911 call with the testimony that you heard. Lauren hit back. There is no denying that. I'm telling it to you. She told it to you on the stand. The words weapon and gun are used. How do you hear those words? The weapon was the paddle that the defendant used to create that big blue bruise on her leg. And the gun was a BB gun. It was not a deadly weapon. Consistency again, the defendant choked her. Cycle of violence. Again, I think you saw a perfect rendition of it live on the stand. Their relationship didn't start abusive. She lived with him for the entirety of their relationship. They had 3 dogs together. They had just gotten 2 new puppies. It was around the holidays. They just had a good time. They were on an upswing. Lauren told you about how their relationship would have these cycles. It was good, it would turn, then it was good again. That's what she was thinking about during this. And that's why she knew that she needed to call the police, because this was worse than every other time that it had happened. Every other time the defendant had gotten in her face and screamed at her, every other time that he had sent her dozens and dozens and dozens of texts accusing her of cheating, this was the worst of it, and she was scared. And here's the kicker, she still loved him. Defense counsel says that the defendant lied to protect Lauren. Lauren lied to protect the defendant.
State you have 1 minute.
Thank you, Judge. That happens in these situations. Even when Lauren was telling officers that he had strangled her and that it hurt and that she was scared and she wanted him to leave her alone, and she wanted him out of her face, she was saying at the exact same time, I love him. I don't want him to get in trouble. I encourage you to watch the entirety of the video from Taryn. Defense counsel jumped around a lot. You watch it from start to end, she says that 15 times. As she is filling out paperwork about how she was strangled, she says that. As she is showing officers how he did it and is showing them pictures, the scratches on her neck, she's saying that. She lied to the police to protect him. And it took being strangled and strangers telling her that she was gonna die eventually for her to tell the truth. We have proved every single element here beyond reasonable doubt 4 different times. We have disproved self-defense, finding guilty.
All right, ladies and gentlemen of the jury, you now have all the evidence in this case. You have the instructions. This should guide you as you go back into the jury room, and you have the closing arguments. We will now be in recess until you reach a verdict. Deputy?
All right, for the jury.
Okay, is there anything we need to take up on the record? State,
Nothing to state.
defense?
Yes, I didn't know if you would, bring up appointing Todd Dudley.
So he's supposed to be here at 11:30,
Okay,
so we'll take it up then.
thank you.
Okay, very good. Good job, everyone, for closing arguments. 11:29, the jury's out.
Before y'all take off, let me make sure I have all the exhibits. Thank you.